Good morning to all of you. Welcome to my interpretation class. Friends, in the last video, we discussed the amending, consolidating, codifying statutes. Today, we are going to discuss the mandatory and directory enactments. Mandatory and directory. So please remember, the act will be telling you, may presume, shall presume, like that. So shall and may. Shall means mandatory. Mandatory means shall. Directory means may. So may, shall and must also etc. They will be used in the enactments. So by that you have to understand that they are mandatory as well as directory. May means it is directory only. Shall means, so in an enactment it is written as shall. Definitely it is imperative. It is obligatory. Almost it is equal to mandatory, right? But on many occasions the court interpreted the term shall may be converted into may will be converted into shall on so many occasions. But as far as the interpretation is concerned, so mandatory means shall or must, whereas directory means may means may or may not. This much we have to remember, right? So mandatory creates duty. Directory means maybe it's only obligatory. It's not a duty, right? If I tell you a couple of case laws, it will be easy for you to understand. Mandatory. Good case. Jyoti Prasad Mittal versus the Chief Justice 1965. In this case, the main case is regarding the age of the judge. Article 217, Clause 3 of the Constitution of India, it was in question. So the Act says, please remember, if any question arises regarding the age of a judge, it shall be decided by the President after consultation with the Chief Justice of India. The decision of the Chief Justice shall be final. Please, consultation with the Chief Justice. Consultation with the Chief Justice of India. Is it mandatory or directory? Shall means mandatory. So consultants, please remember, the consulting cannot become the concurrence. Suppose if the President of India consults the Chief Justice and if he is not satisfied with the opinion of the Chief Justice, yes, he can differ. That's why in a very famous present preview committee chairman of AP, Dr. Shivshankar, Justice B. Shivshankar, who worked as PDJ in Prakasham district. He has filed a case regarding the age, stating that his age was actually by mistakenly written 2 years elder than his real age. So he wanted to consider, but Supreme Court said whenever a dispute is relating to age is there, you have to come to the court as early as possible, but not in the fag end. సో రిటైర్ అయ్యే ముందు వేయకూడదు, ఇది వేస్తే ముందు వేయాలని చెప్పి సుప్రీంకోర్టు ఆ కేసు రిజెక్ట్ చేయడం కూడా జరిగింది. సో కాబట్టి ఏజ్ అనేది, ఏజ్ గురించి కన్సల్టేషన్ అనేది షల్, ద చీఫ్ జస్టిస్ ఆఫ్ ఇండియా shall be consulted. Of course, his opinion may be taken or may not be taken. So this is the meaning of shall. Second, Azad Bharat Finance Company, very famous case. State of Madhya Pradesh versus Azad Bharat Finance Company, 1957 or 51, maybe 57. Here I don't remember. Here what happened is the truck of Azad Finance Company, it was seized by the police since the truck was loaded or was found in possession of the opium. So the police seized the truck for carrying the contraband opium under Opium Act 1948. Right? Here the problem is the respondent, the driver of Azad Finance, does not know the contents. He was just carrying the load from one place to the other, and he has got the waybill. But in the guise of the goods, they have loaded the opium also inside there. So, but as per Section 11 of the Opium Act 1948, the vehicle shall be confiscated. So here it was taken as a permissible enactment. So the court in its wisdom said that because there is no nexus between the driver and the accused person, that is person carrying the opium, yes, the vehicle shall not be confiscated. It may be released. So this is, please remember, otherwise it would be a miscarriage of justice. Yes, ordered for release. See, this is important. Second, directory. Directory means may or may not. N. Nagendra Rao and Company versus State of AP 1994. So here the may has become shall, understand. So Nagendra Rao's property has been seized by the revenue department people, whatever it is, some authority, they have seized the property of Nagendra Rao and Company, right? According to section 3 of the EC Act. And please remember, when once the property is seized, it is their duty, according to section 64 clause 2 of the EC Act. Please remember, to protect the officers may protect the goods seized by the collector. Here the collector has seized them. But of course, if they are spoiled or if they are deteriorated, loss not only to the owner but also to the society. Suppose if the pesticides, manure, okay. If the pesticides are the so-called manure, okay. If they are deteriorated, అది యూరియా పట్టుకున్నారు, యూరియా గోడౌన్లో పెట్టారు, వదిలేస్తే ఏమవుతుంది, వర్షం పెడితే మొత్తం కారిపోతుంది. So they have to take care of the same. So not only to the owner but to the society. And secondly, there may be loss in quality, loss in quantity also. ఉల్లిపాయలు గుర్తుపెట్టుకోండి, ఉల్లిపాయలు సీజ్ చేసి 1998లో. యాక్చువల్గా ఉల్లిపాయల దెబ్బకి బీజేపీ గవర్నమెంట్ పోయింది ఆ టైంలో. సో సీజ్ చేసినప్పుడు ఇమీడియట్గా 6A కింద ఆప్షన్, బికాస్ దే ఆర్ ఆల్ పెరిషబుల్ గూడ్స్. సో ఇది చెప్తే మీకు టైం ఎక్కువ వేస్ట్ అవుతుంది కాబట్టి ప్లీజ్ రిమెంబర్, ఈవెన్ దో ద సెక్షన్ యూజెస్ మే, ఇట్ షుడ్ బి రెడ్ యాజ్ షల్. సో the collector has to form an opinion regarding the category, whether he has to direct their auction, whether he has to send them to another godown and things like that. But if they are damaged, the responsibility lies with the state. So may became shall. Okay, then please remember another case law, Satpal versus State of Haryana 2000. So please remember, when an accused is convicted of a heinous offense and given life sentence, please remember, the authority to grant pardon under Article 161 of the Constitution of India must know the period of sentence undergone. It is a serious case where life imprisonment given. Simply you can't give the so-called pardon or suspension of sentence. Of course, government can give the suspension of sentence under section 432 CRPC. The pardoning authority of the Honorable Governor of the state, yes, he can do it under 161. But the governor in this case showed haste and the file moved so swiftly with unusual zeal and interest. So that means governor has not applied his mind. He passed the order on extraneous condition. The governor was not made aware of the period of sentence, the modified intention. Therefore, so he shall refer to the previous background of the accused person. So with these two cases, you can understand that mandatory may become directory, directory may become mandatory as per the interpretation. That's why interpretation is the job of the court. Okay, with this I am concluding. Thank you very much.